Okay, welcome to the Second International Conference on Future Energy, which will be also in the proceedings form for those who are interested. And our next speaker is a registered professional engineer and inventor, as well as a patent attorney. He's authored 4 books, patented 6 inventions of his own, and published numerous articles. He's listed in the Who's Who of the world, and was also inducted into the Hall of Fame for Engineering, Science, and Technology for inventing and successfully prosecuting the first software patent. He's a frequent speaker and consultant, and he also has a World Future Society chapter in his city, which I attended and was a speaker for. Speaking on the topic of optimum international intellectual property strategy for mitigating litigation risks and emerging energy technology, please welcome Pal Asija.
Thank you very much for that kind introduction. Like many of you, I too have worked for many organizations, and there were always layoffs or rumors of layoffs. Finally, I got so sick and tired of it, I started my own company. And today, I'm happy to report to you that despite the growth in my company, there has never been a layoff in my organization. And you will appreciate why as you examine the organization chart of my company. See, we can get easily stressed and tired after a long day, and you begin to feel almost like sad. And all you have to do is to change your attitude, is just upside down, and now you're smiling. I like that introduction Dr. Tom Malone gave me, because when he came to speak before our World Future Society chapter meeting, a couple of people asked me the next day. They said, "We didn't know you know somebody as important as Tom Malone." I said, "Now you know." Anyway, Pal Asija is my name. Patents are my game. First software patent is my claim to fame. I won't bore you with the whole poem, but you know I wrote a whole poem because I'm so egotistic that I have to do something like that. Now, talking about the stress, here it is what the stress. My question to you is, what do you do when you are so stressed? What can you do? How can you turn stress, say, into something sweet like dessert? So my answer is this. If you're stressed, spell it backwards. And now you have the sweet desserts. So let's look at intellectual property. Intellectual property is divided into many different aspects, like expression and embodiment, and different things are needed to protect different aspects of it. If you look at the idea itself is not really protectable. But if you can reduce it to some kind of an expression, then it becomes a copyrightable expression. Or if you can reduce it to an embodiment, it becomes a patentable embodiment, and there are many different kinds of patents. And we'll get a little bit into that to give you an overview of the things. But let's first of all take away something that is by law non-patentable, like mathematical algorithms or ideas or things people can do without themselves or laws of nature. And you take that non-statutory subject away, then you have these things left. And then you can also take away anything that you can reduce to a patentable embodiment and get the patent on it, or expression. And then anything that is in the public domain, you can take away because somebody else patented before you. And so on. The different aspects are protected by different parts of the laws. Now, this is probably the most information intensive slide. If you look at it carefully, in the center, the ideas are generated. These ideas, some of them will go outside the circle of intellectual property protection, either by your acts of omission or your acts of commission. You don't want to all these ideas to end into public domain. But so you should see your attorney before you do any of these acts of commission and omission which lose all rights for you, and your attorney cannot do anything for you. Assuming that you have the circle of protection and you haven't done anything wrong, you haven't committed any acts of commission and omission contrary to the law, then you have the circle of protection, which can be divided into two halves. The upper half is based upon the concept of disclosure. You teach somebody something new, and in return, the government gives you a monopoly. And there are two ways of those monopolies. But the bottom half is based upon just the opposite premise, and that is you keep it a secret, and you do not disclose it to the public. And these two quadrants protect that aspect. Suppose you can reduce an idea into an expression. You can write a story about it. So you can, in any one of these forms, you can get a copyright, phonoright, trademark, mask works, design patents. They all refer to an expression. But if you can make something out of it, over and above the expression, what law calls the embodiment, then you can patent it. And it can be PCT patent, provisional patent, utility patent, non-provisional patent, and so on. And even within utility, you have all these categories: process, machine, manufacture, composition of matter, improvements thereon, and other embodiments. So you got to keep this in mind, that the expression is copyrightable, embodiment is patentable, and if you keep it as a secret, you have two other options. One is to maintain it as a trade secret, and you will get protection by contract law. Or you can go to tort law and get protection by obfuscation or encryption or some kind of secrecy, and making it harder and letting people know, hey, this is your proprietary matter. You do not expect them to steal it, just as you do not expect them to come to your house or steal your car or anything like that. So that's one view of it. Now here's another way to look at it. What is the intellectual contribution? Well, all intellectual property starts with ideas and other unpatentable subject matter, and then there is expired patents. There's nothing you can do about those. Here you make an intellectual contribution to somebody's idea, your idea, somebody's expired idea, that stands upon its own 2 feet as an improvement. And then that intellectual contribution, if it does not amount to the statutory level, you stop and there's nothing you can do. But if you can, that intellectual contribution amounts to a copyrightable expression, you can follow this route. Or if it can be reduced to an embodiment, a functional thing, a device, something you can touch, see, feel, market, and sell and make money from. So all these things become the option. And the key word again is intellectual contribution. Always ask yourself, what is my intellectual contribution to this idea, before you can definitively answer whether or not you can get some meaningful protection. Now, having gotten an idea, obviously you want to make some money from it. And this is the model we use, that the ideas and seed money, venture capital, angel money come together, we explore it, come up with a business plan. At some stage, it becomes a formal business plan. Then you go through growing pains, and then going public. More money comes in, and then expansion, mergers and acquisitions. And every idea, every business either stays in this cycle or drops out completely as bankrupt. And then here the inventors and the investors have the opportunity to take their money out, because that's why they invested in it. That's why they invented. And here it is. So, but having a good business cycle is not enough. You also need a good team, a board of directors that will give you. And I say have the board of directors as broad as you can. Don't limit it to people in your technology or money or business or something. I like to include people like CPAs, a spiritual leader, a business counselor, an insurance broker. More diverse is your board of directors, better is your chance of success. Now, why is it that some people see new ideas and others don't? Let me ask you this simple question. Do these blocks mean anything? What do they say? Anything? Our pal. Now, those of you who had trouble seeing it probably can see it now, our pal. And even if I take now the aid away, you will still see the our pal, as some people could see it there. So here's the trick. I mean, you have to monitor the filter from which you observe things. It's all there. Some see it, some don't. Those who see it, do something about it, become inventors, and even billionaires. So, but the thing is, problems come when you try to run the business. You say, I've got it fine-tuned, I've got everything in balance, but then something happens in the economy. The balance is dynamic. In other words, this balance is constantly shifting. So just because you have balance today in your board of directors, in your business as a whole, does not mean that balance will continue. So you have to stay always alert to this thing. So the next thing is, what do I need to do? Suppose I find out that I got intellectual property and it's now getting into litigation. Well, and I promised to tell you a few tricks about minimizing litigation risk. So here's what the litigation risk looks like. The prevention is the best cure. The highest of the high roads is that you avoid all dispute. So you think of these things before you apply for a patent, before you draft your patent application, not afterwards. Then if you go into the mediation, it's a little deeper pit. Arbitration is even worse. Litigation is the deepest of all the pits, is litigation. And once you fall into this pit, it's very hard to get out. It's very expensive to get out. You will not be able to survive as a business if you fall into this pit. Attorneys will get rich, but you won't. So that's why time to think of this ADR model and the litigation risk is now, not after you have had drafted your patent application and it is too late to correct. So let's look at a few more things. Requirements for a patent. There are basically 10 requirements for a patent. Okay? All these you can read. And the 10th one is the due diligence. Diligence from conception up until either actual reduction to practice or constructive reduction to practice, which I have not listed here because it was added kind of afterthought. So these are the 10 requirements. It must be new, useful, non-obvious, some statutory, some case law made. But nonetheless, every invention must satisfy these requirements in order for it to be a valid patent. So there are probably out there many invalid patents because they don't satisfy all of the 10 requirements, and the patent office doesn't check for all 3. They are required to check for these 3. Statutory subject matter, new that it did not exist before, and 5 non-obvious. So they will check for these, but they won't check for these. So if you are foolish enough to apply for a patent and get a patent without paying attention to the other 7, you'll end up with an invalid patent. So what's the point? Why is this list so important? I tell you, this list is so important because anything that is not listed on this list as a requirement for a patent means there is no such requirement for a patent. So consider, for example, this short list. Because a lot of people think of imaginary requirements for a patent. Well, working model, it's not a requirement because it wasn't on that list. Even though the patent examiner has a right to ask for a working model when the examiner perceives it to be a perpetual motion machine or as something from nothing or free lunch or something. And in that case, they discourage people. But for the most part, working model is not a requirement in the patent office. All you have to do is make a prima facie case that it should work. It should work. You don't have to understand why it works as long as it works. It's the examiner's job to show you which law of physics or chemistry or mathematics or nature does it violate. and then you can counter back with your legal arguments. Or interview and personal appearance is not a requirement. You can get a patent just by mail. Synergism is not a requirement. Market success is not a requirement, although these things may help. But none of them are legal requirements for getting a valid patent. Even understanding of the invention is not a legal requirement. You don't have to understand it, why it works. Although most inventors do understand how their invention works. But if you don't, that's fine. They're still required to give you the patent. Patent search by the inventor or attorney is not a requirement, although many inventors and attorneys do it for their own good because it makes good business sense. Attorney or an agent is not a requirement. You can file for your own patent and pursue it pro se. And so multiple claims are not a requirement. All these things, none of these things are a requirement. So let me now come to the crux of the story, and that is the PCT application and the international strategy for that international protection. Basically, you can't have everything. You can either shoot for a strategy of maximum economy, or a strategy of maximum efficiency, or a strategy of maximum effectiveness. Unfortunately, you cannot get all three at the same time. But your resources being what they are, your objectives being what they are, you can achieve one and sometimes even two. So what's the main difference between these three strategies? Well, the first one, PCT, is economy. You file single patent application, you postpone all costs to 30 months, and you have a common examination, and you enter the national phase after 30 months, or before 30 months, say 29 months or so, between 29 and 31 months, and you pursue only those countries where you want to, where it is making money for you, or where you expect to make money from it. And that's the cheapest way to do it. And hopefully in 30 months, you might even have an investor. Then you can shift from one strategy to another one. Here's another approach, maximum efficiency. Just go directly to the countries you want patent in. Forget the PCT, forget the regionals, forget any other approach. Just fix, if you only want 3, 4, 5, or 7 countries, pick them. It'll be the most efficient, shortest route to getting patents in those countries.
Isn't there a rule that you have to file with the United States before you can get a patent in another country to make sure it's okay with them?
Yes, you have to either file in US first, if it was invented in US, or you have to get a permission from the patent office that you can file abroad first. But I think we better hold off the questions to later, otherwise we will miss the overview. And then the third approach, which is the rich man's approach, which is what the corporations take into consideration, and that is you file concurrently a PCT application, regional application, and national application. And then you can go, what's the advantage of doing that? Because you will get 3 bites at each apple. From each country, you will have 3 chances. First you file in the US, you get rejected. You've got the PCT, you got so on. And then there are regions in Europe, Africa, Eurasia, and so many countries. So many countries are covered by at least one region that you can easily get 3 bites at the apple, so to speak. Now, what are some of the problems with these energy inventions? Well, the problems are the same which I faced when I tried to patent my software. In late 60s, I had invented some software. I went to a patent attorney to get a patent for my software. He says, no, I can't help you. The United States Supreme Court has said that software is not patentable because it is like mental steps. So I had no choice. Same day I decided I was going to go to law school, graduate, finish law school, pass the state bar, pass the patent bar, and the year I did that was 1973. So in 1973, I filed my own software application. And you should know why I believed that. I believed that because nobody else believed in it. I believed that because of the trade-off in the marketplace between the software and the hardware. Because I can take the best features of the best hardware, put it in the software, and then nobody can tell me non-patentable subject matter software is infringing some patented hardware. because that would be so illogical. So based on the strength of that argument, I decided to pursue this route all the way. And eventually, in 1981, the patent issued, and I wrote a book about my experience, how to protect computer programs. Now, of course, everybody's doing it. But when I started it, there was no such thing as software patent. In fact, not only there was no such thing as software patent, people used to say not only software is not patentable, it may not even be copyrightable. And even companies like IBM didn't copyright their software in those days. But now, of course, the situation is just the reverse. Not only software is copyrightable, but it's also patentable, and everybody's doing it. Not only software is patentable, but also business methods are patentable. Even mathematical algorithms are patentable. But that same bridge is now being crossed by energy inventors, especially zero-point energy inventors. And some of them are having a tough time. Some are not. So it all depends upon craftsmanship. What words do you use to describe your invention? It's like the Casimir effect and the Van der Waal effect. You know what I mean? So which words you use depends upon whether or not your paper gets published. Same thing with the patent office. Depending upon how you draft your claims, you may or may not get a rejection on non-statutory subject matter because it's a free lunch or something for nothing. You know, I mean, as scientists, you all know how busy you are and how stressed you get. And I already showed you one of my balances. And one of the things that you should always aim for is to have a balanced, I mean, I showed you my balance before, that you should all have a balanced meal. But you know, to a scientist, what does a balanced meal means? I figured out the hard way. They go eat on a fly because they only have 15 or 20 minutes to do it. And in their mind, what they do is they put French fries and peanuts in one side of the balance and a mug of beer in the other, and it balances, and they've got a balanced meal. But that's not the kind of the balance I'm talking about, right? I have, you know, people often ask me, what is your secret of success? Why are you so successful? Well, how did you become so successful? By winning cases. What's your secret of winning cases? Experience. How did you gain experience? By losing cases. So, as a novice, I lost cases unnecessarily I should not have lost. As an experienced person, I'm winning cases I should not win, but on the average, justice is being done. So, some people accuse me, they say, oh, the reason you are successful is because you are a yes man. I say, no. When my wife says no, I say no. So I'm not a yes man. So what is it? Is it a no or is it a yes? Is it like, you know, that date rape case that went to the court, and it says, well, she said no, but yes was written all over her face. And that's the defense they used, if you can believe it. Now, in my vast experience of dealing with scientists, and also, you know, being an amateur scientist myself, I have divided scientists into 5 types. And here are the 5 types. I think you will love them because I love them. First, those who don't know and don't know that they don't know. They are naive. Nurture them. 2, those who don't know but know that they don't know. They're learners. Mentor them. And 3, those who know but don't know that they know, they're asleep. Wake them up. And 4, those who don't know but think that they know, they're dangerous. Avoid them. And 5, those who know and know that they know, they are real scientists like Archimedes, Newton, and Tesla. Emulate them. And in this list, maybe you and me also. Who knows? So, what is the story behind the mental steps doctrine? This is the most difficult rejection I faced when I went before the United States Patent Office for getting the first software patent ever issued anywhere in the world. And that was in 1981. And here it is. See, they were saying unpatentable subject matter, walking, mental steps, You add mental steps to it, you add inventing skills to it, and you make it a patentable subject matter, for example, by adding bicycle or software. And to exclude software because it resembles more like mental steps would negate the whole model. But every invention, by definition, must involve mental steps. And if the patent office gives you a mental steps rejection, they say, well, how else can I invent without mental steps? I mean, that's the definition of the patent law. It is a branch of intellectual property law. It is the intellectual contribution. It is the mental steps contribution. But somehow they couldn't clearly see that the mental steps applied to invent is not the same thing as somebody mentally doing mathematics in their head or thinking about some dirty Playboy magazine. Because those are not patentable. But those are different. Those are walking and mental steps without anything. This is mental steps added to one of those activities to make it something more useful, beneficial, and so on. So, let's keep going. Prosecution strategy. Because strategy and tactics, they kind of go together. But strategy is always more important than tactics, just as vision is more important than goals. Prosecution strategy, always choose the correct semicircle. I showed you 2 semicircles in the sphere of protection. Separate real and virtual issues. Divide issues into legal, factual, and policy. Draft flowcharts and specs. And we need similar list for strategy, not just for software, but every kind of new invention barrier that we come to. And today, energy inventions fall in that barrier. And we have to have a strategy that is much like this, including the double affidavit practice. And you can read a lot of this stuff in my book if you are interested, but I'm not so sure that software and energy have enough in common, except that you might be able to analogize it. One of the organizations, and I belong to a lot of organizations, by the way, and one of the organizations I belong to is called American Trial Lawyers Association, or ATLA. And this year in Seattle, they changed their name. For some reason, they were getting bad image for trial lawyers. So they said, maybe we'll change our name and it'll improve things. So they changed their name to American Association for Justice. So ATLA is now known as American Association for Justice. But anyway, that's just happened this last September, this last month. And now, but as a trial lawyers, as American Trial Lawyers Association, on their letterhead and everything, they had a slogan. And their slogan was a short takeoff on this bad reputation thing, which everybody says, let's kill all the lawyers. I think it was one of the Shakespeare's novels or plays. So let's kill all the lawyers. And the ATLA came up with a slight parsing improvement on that slogan and adopted their own slogan. So instead of being, let's kill all the lawyers, their slogan is, let's skill all the lawyers. So they take pride in providing continuing legal education for the attorneys. All right. Litigation paradox. In addition to avoiding the litigation pit, which is sometimes too late when you go see the attorney for the first time, the second best thing that you can do when you are so close to the litigation pit is the litigation paradox. Remember that even if you cannot afford to go to trial, the more you are prepared for trial, better is your chance of avoiding it. So you and your attorney have to convince even the juggernaut or the IBM or the United States government that even though you're a small David, you are ready to sue Goliath and you will win. And you keep creating that impression through PR, through many other ways, chances are you might avoid it. But there's no guarantee. But then there's no guarantee in life in anything. Another tip on this is called the Festo factor. That's the infringement under the doctrine of equivalence is not available to patentee if the claim element was narrowed during the prosecution. Now, what does that mean? That means if you cannot have infringement under the doctrine of equivalence, you may not have infringement at all. And what can you do about it? Nothing. Because the time to avoid this problem, this trap, this litigation pit was during not the drafting of the application, but the prosecution of that application. So you have to now draft the patent application carefully, then you have to prosecute it carefully for pitfalls like this to avoid. So, but don't confuse this Festo factor with the Internet factor or the Feist factor. Feist factor is the copy law court-made doctrine. And we don't have too much time to go into all of those. So I want to give you just an overview of the few of the things. I don't know how I'm doing for time, but I'm hoping there's enough time. Somebody will tell me if I'm running too short. Here are the limitations of some of the trade secrets. A lot of people say, oh, well, I don't have a patent, but I'm signing everybody to have a confidential disclosure agreement with me, and that will protect me. Maybe to a degree, but with these limitations, it's easy to see why it may not protect you. First of all, these limitations apply to every one of those inventions. If they are not protected, I mean, they apply to Coca-Cola, Listerine, the successful ones, the bad ones, but they do apply to all of them. So Coca-Cola spends a fortune in trying to avoid these things so that their trade secret continues powerfully. See, if the infringer independently discovers it, you have no recourse. Or if the infringer is a bona fide purchaser, or the infringer cannot be found, or if the person you disclosed it to sends it to his friend in Kentucky, you have only recourse against the person who signed that form, not to everybody in the world. So if you cannot prove the nexus between this infringer who claims to be, hey, I came up with the same idea of my own, and you cannot prove him that no, his cousin or somebody else from the company showed it to him in every detail. So anyway, but you can follow up on this list later on, because I think you will get most of this information in the proceedings that Tom promised. Now here's another way to look at it. Intellectual property. How is it earned and how is it infringed? And we identified earlier in our circle of protection these 4 or 5 different aspects: copyrights, trademarks, patents, trade secrets, technical protection. So they are all earned by a different method, and they protect a different aspect of the same invention. Copyright by creation, trademark by use, patent by constructive reduction to practice, and secrecy and contract for trade secret, technology for technical protection, encryption like the Enigma code and so on. Infringed by copying, counterfeiting, actual reduction to practice, theft or breach. Now, why is this list so important? This list is so important because whenever you come to a decision about suing somebody or being sued, and you have to decide, do you want to settle or decide or give up or what, you have to ask yourself the key question, that is the aspect protected exactly match the aspect infringed? And if it does not exactly match the aspect protected with the aspect infringed, you are just wasting money on lawyers. Lawyers on both sides will get rich, but neither party will come out winner. Even the party in whose favor the jury rules the verdict would be a loser. That's so bad it is. So make sure. And why do attorneys take cases where the aspect infringed and the aspect protected do not exactly match? Because they make good money that way. They have no reason to tell you. They say, oh, well, I didn't know. I thought, the inventor knew he had a case, or whatever. So you have to take certain amount of responsibility and be in the driver's seat and be in charge of all of that protection and everything. So let's look at a little bit more about infringement, misappropriation, piracy, counterfeiting. These terms sometimes are used interchangeably or loosely, but they have a very definite meaning in law. So if you compare the trait of this with the misappropriation method or nomenclature, you will find this. This matrix kind of defines all of these three characteristics in their full format. Now, I make fun of lawyers, I make fun of myself, I make fun of engineers, and I thought you might like being made fun of somebody else, because as engineers and scientists, you will really appreciate this one, because this is really, I could not figure out. And this one I'm making fun of comes from the legislature. Can you imagine that? Legislature. Now, this is what the legislature in Texas did. What did they do? They passed a resolution that pi is not a convenient number. So they made pi to be even 3 instead of what it is. You know what I mean? And where were we? How many legislatures voted on it, passed the resolution? Did it change reality? No. Same thing with my software patent application. Just because an inventor chooses to claim a software invention in hardware terms versus software terms determines whether or not you get your patent, or at least in those days. But really, should it matter? I think if you are honest with the patent office, that here, this is a software invention, I honestly tell you that this is more practical. That's how I intend to practice this as a software invention, and you would not get a patent. But if you were to say, oh, this software really revolutionizes the computer, so I'm claiming a new computer, not new software, but new computer, you might get a patent. So those technicalities and differences are easy to see when I look at this and say, oh, if the Texas legislature thinks that they have the power to change the value of pi, or the US Supreme Court thinks it has the power to decide whether or not software is patentable, all they should do is say either no hardware, no software is patentable, or both patentable, or neither. But they can't have one without the other, because in the marketplace, there is a trade-off between the hardware and software. Let me quickly go back a little bit to that business model I showed you, because that's where most inventors falter. Not that they cannot get a patent. I can get patent to just about anybody. But where they falter is that they cannot raise money, they cannot build a team, they cannot involve right people at the right time with the right resources. Maybe they lack social skills. I don't know what the problem is. But raising money is a very important part of it. So here, for example, this was a very modest inventor who was looking for money to try out his invention, to commercialize it. He knew a very rich uncle. So he actually sent an email to his uncle saying, this is where I stand. Maybe he'll give me my money. He'll give me some money because he's rich. He doesn't know what to do with his money. But uncle, will get his chance. But this is the letter he wrote. He says, "Dearest Uncle Rich, thank you for your snail mail wishing me business success. Entrepreneurship is great. I am making lots of contacts. I am in process of selling several of my super duper inventions, but it's not easy. With all my stuff, I simply cannot think of anything I need except your good wishes, or you can just send me a card because I would love to hear from you as soon as possible. So the nephew thinks that he's being so tactful that uncle's heart will melt and he'll say, oh, here is $1 million. Why don't you go and try the invention? So the uncle gives a reply. He says, okay, dear innovative Snoopy, I know that economy is not good, but I am confident that you have enough going for you to bring honor to us all. Do not forget that the pursuit of knowledge and innovation is noble. You can never innovate enough. Do write me now and then, even if you need nothing, or send me an email, rich@juno.com. With love. So you see, you can match the wits, but he still didn't get the money. What's the point of that slide? It's not easy raising money. The only chance you have of really getting money, I think, is from some inventor who 30 years ago went through what you are going through now. But he made it. He became a multi-millionaire or multi-billionaire these days, because millionaire is not very rich these days. So that person can sympathize with you, how he was helped, how much it could have helped him if people have done more, and so on. And all those things go into that equation. And therefore, it is to your advantage to keep looking for the person who has gone through the same pain you have gone through. Now, of course, it's not easy. Networking is not easy. Even though mathematically it's very easy, it only takes 3 hops. There's everybody in the world can reach anybody else in the world in 3 or 4 hops, because you know somebody who knows somebody who knows somebody who knows the target person you want to talk to. So it's in 3 hops is for US, and 4 hops is for the worldwide. So if there's a person you want to make contact with in India or some other country, you can do it in 4 hops. But you just have to find those 3 intermediate people to make that connection. Okay, let me show you a couple more things, a little bit like that. Where is my little wheel? Did it fall down? It's in the slides, right? Yeah, there it is. Okay, now part of it is having fun while you're doing it. And this is what my vision is. He says, you choose to have fun. Fun doesn't come automatically. You have to make a conscious decision. And then fun creates enjoyment. Enjoyment invites participation. Participation focuses attention. Attention expands awareness. Awareness promotes insight. Insight generates knowledge. Knowledge facilitates action, and action brings results. So I share these things with you because they might help you, because they helped me. Now, how about becoming, say, a better person? One of the things I crow about is 3P skills. That is, that regardless of what profession you are in, you can improve your chances of success just by improving these 3 Ps. First, for perception. 2, for processing, which is mostly mental steps, the brain, thinking. And third, your presentation skills. If you improve on each 3 skills, I can guarantee you that you will improve in your profession, regardless of what your profession is. So keep looking for better methods for perception, which is mostly observation skills and listening skills. And then processing is mostly memory and thinking skills. And then presentation skills is what we've been doing here at this conference all along. So a lot to consider. Now, if you look at the systems view of things, this is what it boils down to, in my opinion. Regardless of what invention it is, what you're manufacturing, what you're selling, what you're developing, Every system has these 5 steps in it: an input, a process, an output, a rest, a purge. Purge meaning some waste comes out of it. Regardless of whether it is a system existing in nature, whether it's a man-made system, whether it is a manufacturing firm, whether it is a marketing business, every business has all these 5 components. And the output of one system may become the input to another. Even the waste of one system may become the input to another system. And input can become output, and with the feedback loop. So in other words, you can chain them together, not only as a daisy chain, but also as a parallel chain. So how do I know that this system works? Because I've tried to analyze many different systems with it. For example, here let's look at some systems where I say, on the left side, these are the 5 steps I said that every system has, regardless of whether it is man-made or God-made. And these are the systems, say manual system, physical system, mental system, spiritual system. Regardless of what it is, here are the 5 steps for each. Okay? If it's a manual system like a manufacturing plant, you may have raw materials, you may have actions for processing, preventive maintenance, waste, product or service, final output. Same thing if you look at the physical. If it is a physical system, you'll have food, air, water, sunshine, exercise, yoga as processing, sleep, rest and recreation, and all this purging and helping others. And then mental systems also have the same kind of 5 steps. And same thing even going on to the spiritual steps. So is that enough? I mean, is it only applicable to human beings? No, it also applies to animals and plant life and everything else. Again, these are the same 5 steps we had for the manual system. And then we have this animal, food, air, exercise, sleep, which is similar to human being. And then you have these steps on natural or plant life. Plant life also has the input, output, seed, water, sunlight, photosynthesis, hibernation, gases, leaf, fruit, vegetables, and all kinds of things. All of the steps keep repeating regardless of what kind of system it is. And it goes even mega scale to the cosmos. And this it is, in the cosmos there are elements, movements, change, calamities, rain, light. So I've been given the signal that I have less than 5 minutes, which I think I should leave for questions. So with that, I would like to thank you for your privilege and the company. That's not the end you had in mind. Anyways, that's all. Maybe I still have a couple of minutes for the questions.
Anyone have any questions? There we go.
Either I confused everyone. Oh, yes, sir.
What if they slap a national security act on your invention? Is there a way of perhaps bringing it in front of a grand jury because they can handle top secret information?
I'm not so sure that the Patent Office or the National Security Council, because normally those proceedings are secret. Now, I'll be honest with you, throughout my career as 33 years or 4, I have never had a secrecy order placed on it. I mean, I had one that went for consideration, but the committee decided it was not. It was just, So, and this was a briefcase type system where designed for the Secret Service to protect the president. And they said, no, this is okay. And they let that go through the Patent Office. But had it been a secret conclusion, I don't think there's much my client could have done. And then if there is some, grand jury proceedings, but I don't think there is any provision in the law for such things.
You would be able to bring it in front of a grand jury. Usually,
but the grand jury, according to the law, is not qualified for these things. So they
can't handle top secret information.
They can't handle it?
Yeah.
So, well, maybe that's something to try. Like I say, I have never had that opportunity. So, yeah.
You will.
Maybe I will. Yeah. Any other questions?
You had a question over here?
Yeah, yes, sir.
NASA filed this patent relating to electrogravitics, and it's clear that there was earlier patents filed by Brown. Would they do that to put a chilling effect on, if there's a patent out there and it doesn't meet the criteria that you listed, what can one do about that without litigation?
Well, you need to develop both an offensive and defensive strategy, which means that not only you have to be prepared for litigation, but you need to also have an improvement in your own mind of the same invention, that even if you are not 100% sure that meets all of the criteria, you'll work with your attorney in crafting the claims, scope, and language so that you at least get prima facie valid patent. And that can be a very strong negotiating chip if you get sued. So you need to balance the offensive strategy with the defensive strategy, even if you are on the losing side. I mean, you're the later Johnny-come-lately inventor, and somebody else did it 50 years ago or 10 years ago. Time is up, eh?
We're running behind.
Oh, I'm sorry.
But thanks.
Thank you.